Yes.
It please your lordship. Your lordship, last Friday I filed one civil revision petition, but the matter is yet to be listed, so I'm making mention this morning. Apparently the registry has shortage of staffs, but it has already been 8 days today. That's why I'm making a mention, your lordship.
But civil revision, don't you think that it has?
Your lordship, I'll go and mention there.
Yeah, better.
My lord.
I'm not taking up that page.
Oblige, your lordship.
Please, Your Lordship. Lordship, I beg to mention item number 8, Your Lordship. We have received a counter file by the state, so I may allow some time to file my reply, Lordship.
Very short list.
Lordship,
The list is very short. There's no matter at all. What will I do if you take an adjournment? We'll see whether it is required or not to file a reply. Required?
yes, Your Lordship is required.
What is the case about?
Lordship, the petitioners are Ayush doctors, Your Lordship, who have served during the COVID-19 pandemic, Your Lordship. So we are praying for creation of posts to absorb them in for regularization, Your Lordship, just like the allopathy doctors, Your Lordship.
What happened to those matters where during the COVID period, these people were given, there was a matter, no?
Yeah,
Where
regarding
the nurses as well as the doctors also.
yes.
What happened to those?
The doctor's case.
The
it's
doctor's
disposed-
case was dismissed by the single judge.
Yes.
The matter went to the division bench. I think the division bench upheld it. This was a case where
Yes.
these doctors' cases, why are you giving an additional benefit to those persons
Mm.
who worked during the COVID
Mm.
period? Then the learned single judge held that no,
Mm.
they are not entitled because they are a separate class altogether.
Mm.
So therefore they don't have a claim, which led to some agitation or something. Matter came up. The division bench, initially I stayed it, but I think the division bench dismissed the appeal.
No, the division bench upheld it. Upheld the single judge.
That is why.
Oh,
Dismissed the appeal.
yes.
When it dismisses the
Yes,
appeal,
yes,
it upheld the learned single
yes.
judge.
And the petitioner now they went up to Supreme Court, but the Supreme Court did not interfere.
Okay.
Yes.
So you are during the COVID period.
Yes, Your Lordship,
Yes,
Ayush
but
doctors.
Lordship, here in this case, they are under centrally sponsored scheme. They are the SSA. They were appointed under the scheme, not under the state
And
cadre.
the scheme is over.
Still
No, Lordship,
continuing.
Still continuing, Your Lordship.
It's continuing.
Yes, Lordship. But we have also served during the COVID-19 along with the allopathy doctors in the same hospitals, Your Lordship, giving same services, Your Lordship.
Okay, you want to take an adjournment. Counsel appearing on behalf of the petitioner seeks an accommodation to file an affidavit in reply. Because taking into account the above, list this matter on 25th June. You can file your reply by then.
When is it? Lordship,
On 25th June, in the meantime, the reply be filed on behalf of the petitioners.
Much Lordship.
I praise your Lordship. Lordship, I beg to mention hearing item number 15, Lordship. Lordship, here, standing counsel for NIGTCL has some personal difficulties today, so I have been instructed to pray to list the matter on Monday, Lordship.
No objection.
Monday?
Yes.
Why Monday? Urgency? What is the matter about?
I'm praying for the spot verification, joint spot verification of the damaged properties along the national highway.
Ah.
Yes.
Urgency? No urgency.
I can wait till Monday.
You have urgency? No urgency. Okay. At the request of the learned counsel appearing on behalf of the
NIGTCL.
NI
NIGTCL. NHITCL.
or NHIDCL.
Lordship.
So you are asking for some compensation.
At this stage, I'm praying only for the spot verification of the damaged properties.
Oh, then we have it on Monday. This is a matter which could have been done now only. It doesn't take a long time. Okay, at the request of the Learned Counsel for the NHIDCL, the matter stands adjourned to be listed again on Tuesday.
Lordship.
Rustam.
Obligation.
Right.
Promotion, item number 1.
Yes, what is this? Same matter.
Yes, my lord, in this matter, the state government, along with the NHDCL, have carried out the joint spot verification of the damaged properties and have submitted its assessment report. I have
Then,
an assessment report. I have annexed on annex 4, page 21.
and they have not made the payment.
No, my lord. Page 21 and 22. The particulars of the damage.
This is making it returnable on 23rd of June 2026. Where's that NHIDCL council? Just now he was here, no? Yes, you come over. Your senior is the standing council.
Lordship.
Yeah, take notice. Mr. So-and-so. Mr. Lonkoma accepts notice on behalf of respondent number 1, 5, 6, 7. Mr. So-and-so accepts notice on behalf of respondent number 2, 3, 4. Where is who will be Mort you can take? No.
Lordship.
Okay. 2, 3, 4, and 4. Pustam. Extra copies of the petitions be served upon the learned counsels appearing on behalf of the petitioner, on behalf of the respondents. Today? Monday?
My lord, respondent number 2 will be through CGC.
Huh? Or respondent number 2 will be CCC.
Yes, my lord, Sindhi
This
Ministry
is
of.
what I'm saying. Where is Mr. Yangavati, Mr. Nugule, anybody, any juniors of them? No, government. You have not served copies upon the CCC.
Yes, my lord, I have not.
Okay, their names have not been shown. Anyways, except respondent, he accepts notice on behalf of respondent number 3 and 4. Extra copies of the writ petition be served by Monday upon the councils. As regards the respondent number 2, the learned counsel appearing on behalf of the petitioner has submitted that the said respondent is to be represented by the central government council. He further submits that in the Kohima bench of the Gauhati High Court, there are 2 counsels who have been appointed as the central government council. The counsel for the petitioner is directed to effect service upon Mr. Yangavati, the learned CGC, on behalf of the respondent number 2. Who's next? This is the second round of litigation
Yes, my lord.
whereby the petitioner have approached this court, whereby the petitioner has been claiming compensation on account of damage caused to his property upon construction being carried out by the NHIDCL. Mr. So-and-so, the learned counsel appearing on behalf of the petitioner, submitted that in the earlier round of litigation, which is WPC number 310/2023, the learned coordinate bench of this court by an order dated 3/34/2024 directed the respondent authorities in the said writ petition, and more particularly to the respondent number more particularly to the executive director of NHIDCL, as well as the respondent numbers, as well as the deputy commissioner, Junebetu, to dispose of the representation of the petitioner dated 27/7/2023 by passing a speaking order. Thereupon, as the speaking order was not passed, the petitioner was compelled to approach this court by filing a contempt application, which was registered and numbered as COPC 4/2025. In the said contempt proceedings, the Deputy Commissioner Junebetu had produced the damage assessment report, which was to the tune of rupees 1,57,27,958. And it is on the basis of the said damage assessment report produced, this court had closed the said contempt application. However, more than a year had passed by, the said amount having not been released to the petitioner is compelled to approach this court by filing the present writ petition. The respondents herein are directed to apprise this court as to why the compensation as assessed by the Deputy Commissioner Junebetu have not yet been paid to the petitioner by filing their response on or before the next date.
For admission, item number 2.
Yes, madam.
Yes, may I please, Your Lordship? Your Lordship, as per the affidavit of opposition filed by the state
Passionate
respondents,
appointment.
compassionate appointment is.
Is your serial number?
As per the affidavit in opposition filed by the state respondents, the petitioner is in serial number 2 under Peck District.
What do they say?
However, Lordship, in as
On so and so has submitted before this court that the petitioner was placed as serial number 1 under Craig in waiting list for comparison, that her case for comparison. So, however, on careful scrutiny of the compassionate appellate, it was found that the order dated here, the owner had directed us to consider the case of the petitioner for appointment. The deputy was filed by so and so, whose husband had died in harness. At the time of disposal of the petition, the year stood at serial number 21 in the waiting list for the appointment. That, however, the case of the petitioner is yet to be considered since her turn. Okay. So yours is at serial number 21.
no, Your Lordship, as per my, I have filed.
And further respect,
reply.
since the petitioner had serial number 2 under Peck District in the waiting list for compensation, the appointment of the on shall be considered commensurate to her qualification as and when it counts. This is as such in concerning to the within list of the email on the government petitioner's name. The petitioner now has serial number 2. So your case will be considered after the petition one
Yes.
CASO is appointed.
Yes, however, Your Lordship, there is no indication in the office memorandum dated 17 September 2015 that appointment should be district-wise. Appointment may be given under any district in the state of Nagaland, Your Lordship. And placing the petitioner at number 2 is discriminatory. And also, as I have mentioned in my petition, the later appointees, they have been given appointment. However, my case has not been considered yet.
Where is your name district wise?
Page 14.
Page 14. Where is the petitioner's name?
The second name, Your Lordship.
Oh, yes. Father expired. Father, whose
Under,
father? Father expired in 2016.
Yes.
yes, Lordship.
Okay. So you'll get when your term comes.
Yes, however, there is no indication that compassionate appointment has to be given district-wise. So it may be given in other district also under the medical department, Your Lordship.
Well, how will you go and stay in other this? Huh? If you are given out there in Futsara, why will you stay there? Huh? No, no Kuksum. You are from Heck.
Yes, Lordship.
Heck is a
Or
cold
should I
climate.
reply?
If you are given tomorrow in Dimapur, what will you do? It is their policy. Why should we say? Anyways, you are number 2. They will consider when your turn comes. We dispose it
May I
off.
please, Your Lordship? As I have mentioned in my petition that at the time of applying for the compassionate appointment, there was vacancy available. If Your Lordship may kindly turn to annexure 5 of my affidavit in reply.
Next year. 5.
Page number 13, last page, Your Lordship. In my affidavit in reply.
Remember? There's no affidavit in reply here. We have an affidavit in opposition. There was the post vacant then.
Page number 20, Your Lordship, in
Of
the
your
original
petition.
petition.
Okay.
There at serial number 4, vacancy was available at that time. However, the appointment was not made, given.
Now the question arises whether there is vacancy or not.
Yes. However, at that time, no appointment was given, so therefore it was illegal, discriminatory. And the later appointees also, as I have mentioned in the petition, annexure 17. Page number 17, annexure 4. The appointment was given to a later applicant. And my case was not considered. However, the later applicants were
This appointment has been given to whom?
one Mr. Sisinguli Solo. However, I'm not contesting his appointment. I'm
Then?
merely showing that it's illegal.
Madam, I don't think you should make it complicated. A simple thing. Chalo, we dispose it of as per the affidavit, and whenever your chance comes, you are at serial number 2, the moment the vacancy arises, you will be given. Heard Ms. So-and-so, the learned counsel appearing on behalf of the petitioner. Mr. So-and-so appears on behalf of the respondent numbers 1, 2, and 3. The petitioner herein has approached this court, being aggrieved by the inaction on the part of the respondent authorities in not considering the case for appointment of the petitioner in terms with the office memorandum dated 17/9/2015. It is the case of the petitioner that the petitioner's father, late
Mother. Yes, Lordship.
petitioner's mother, late Saliovino, died in harness on 25/8/2016. At that time, the petitioner's mother was working as the cook at Naga Hospital, Kohima, Nagaland, under the Health and Family Welfare Department, Government of Nagaland. The petitioners submitted an application on 29/8/2016 to the Principal Director, Health and Family Welfare, Nagaland, Kohima. And the said application was duly recommended and forwarded to the competent authority for consideration of appointment under compassionate scheme as per the rules of the said scheme. Pustu. It is the further case of the petitioner that the Principal Director Directorate of Health and Family Welfare, Nagaland, had also made a declaration on 5/6/2023 certifying that the petitioner's family does not have any family member employed in the government service, thereby eligible for compassionate appointment as per the office memorandum serial number 6 of compassionate appointment scheme as per the documentation. Pusto. As there was no consideration, as it is alleged by the petitioner that there was no consideration of the petitioner's case in terms with the office memorandum dated 17/9/2015, the petitioner had approached this court by filing the present petition on 11/11/2024. The record reveals that that this court, by an order dated 12/11/2024, issued notice. Subsequent thereto, an affidavit in opposition has been filed by the respondents numbers 1 to 3. In the said affidavit in opposition, which have been filed by the Additional Secretary, Health and Family Welfare Department, it is mentioned that the case of the petitioner is under consideration. And as per the list maintained district-wise for appointment on compassionate grounds, the petitioner's name stands at serial number 2. The district-wise grade 4 compassionate applications till March 2026 have been enclosed as Annexure 3. This court finds it very pertinent to reproduce paragraph number 4 of the said affidavit in opposition. Inasmuch as in the said paragraph, it has been categorically mentioned that the petitioner would be considered as and when her turn arises, accrues, and upon availability of a sanctioned vacant post. Paragraph 4 of the said affidavit is reproduced hereunder. This court have also taken note of the submission made by the learned counsel appearing on behalf of the petitioner, that the petitioner had submitted the application in the year 2016, and on account of the application of the petitioner being considered on a district-wise basis, which is otherwise not the mandate in terms with the office memorandum dated 17/9/2015. The petitioner, as on date, is being still required to await for appointment on compassionate basis, that is a decade after the death of her mother. The learned counsel therefore submits that the learned counsel therefore drawing reference to the district-wise grade 4 compassionate applications, which is Annexure 3 to the affidavit in opposition submitted, that in many of the districts, the persons who have applied much later would be granted appointment on compassionate basis on the ground that if compassionate basis. Though the person against whom the person against whom claims have been made have died much later. The Learned Council further referred to clause 1 of the addendum dated 9/4/2019 and submitted that the compassionate appointment to Group C and Group D posts under the scheme were required to be strictly in order of the date of death, and first preference should be always given against those who have died earlier. And under such circumstances, allowing the appointment on the basis of compassionate appointment in certain districts of persons who have died much later than that of the mother of the petitioner is not only not only contrary to the scheme, but also violates the mandate of Article 14 of the Constitution. That's your submission, madam.
Your Lordship, on that note, I would just like to place one OM. This gives for appointment of grade 4 for indigenous inhabitants. So on the basis of this OM, this district-wise has been maintained, Your Lordship.
Mr. Longkumar, the Learned Counsel, appearing on behalf of the respondents, submitted that appointment on the grounds of compassionate appointment is an exception to Article 14 and 16. And it is on the basis of a policy of the government to provide succor to those persons who have suffered on account of the sole breadwinner of the family having expired. He further submitted that there is an office memorandum issued by the Personnel and Administrative Reforms Department dated 4/6/2016, wherein it has been mentioned that in respect to recruitment of grade 3 and grade 4 posts in the district offices, all direct recruitment vacancies occurring in grade 4 posts in the district offices shall be filled up by the indigenous inhabitants of the respective districts.
Your Lordship, that is for direct appointments are not applicable to compassionate appointments scheme.
He therefore submits that it is on the basis of these office memorandum being applied to the office memorandum dated 17/9/2015, the respondent authorities have maintained a district-wise list
Lordship.
for appointment on compassionate grounds. This court had given an anxious consideration to the respective submissions and have also perused the materials on record. The materials on record, and more particularly the paragraph number 4 of the affidavit filed by the respondent numbers 1, 2, and 3, as quoted herein above, shows that the petitioner herein case is under consideration, inasmuch as the petitioner is at serial number 2 of the list insofar as the fact district is concerned. It is also mentioned in the said paragraph that the petitioner's case should be considered as and when there is a vacant sanctioned post available. Next. This court have also given an anxious consideration to the submission as to whether the appointment on compassionate basis should be made on as a district wise, or there's a requirement of taking into consideration the all the applications together, irrespective of the district. First, the settled law stipulates that appointment on compassionate basis is not a source of recruitment. It is rather based upon a policy of the government to provide succor to the family on account of the death of the sole breadwinner. The office memorandum dated 17/9/2015, which have been enclosed to the writ petition, categorically mentions that appointment on compassionate grounds shall be made only on regular basis to direct recruitment posts, and only if regular vacancies meant for that purpose are available in the department where the deceased government employee was serving. It is also relevant to take note of the office memorandum to which Mr. Longkumar, the learned counsel appearing on behalf of the respondents, have made reference to, which stipulates that all direct recruitment vacancies occurring in grade 4 posts in the district offices shall be filled up by indigenous inhabitants of the respective districts. Under such circumstances, in the opinion of this court, maintaining a district-wise list by the respondent authorities cannot be said to be unreasonable or contrary to the office memorandum. First, under such circumstances, the instant writ petition stands disposed of with the following observations and directions. Number 1. The petitioner herein be considered in terms with the office memorandum dated 17/9/2015, read with the addendum dated 9/4/2019. Number 2. It is seen that in the fact district comma, the petitioner's name is at serial number 2. And the petitioner have awaited almost for a decade. Under such circumstances, as and when there is a vacancy arises, the petitioner vacancy arises for filling up the post, as and when vacancy arises, for the petitioner to be granted appointment, the respondent authorities shall grant appointment to the petitioner on compassionate grounds. In terms with the office memorandum dated 17/9/2015. First, this court further observes that as the petitioner had filed the application within the stipulated period as mentioned in the office memorandum dated 17/9/2015, comma, there shall be no denial to the petitioner's application. The petitioner should be granted the necessary age relaxation as for filling up for her appointment to the post.
Obliged, Your Lordship.
Obliged, Your Lordship.
For admission, item number 3.
Yes.
Lordship, here I'm praying for appointment on land ownership basis, as well as I'm challenging the appointment of respondent number 6. The petitioner is the nephew of late Dr. P. Neoto GC, who is the founder of Neoto village. And the petitioner uncle has donated a plot of land measuring about
Yes.
Lordship, notice upon private response number 6.
Forget about them. Private response.
It's
You
completed.
don't have a case.
Yes, Lordship.
You don't have a case because of the fact that the doctor who had donated the land, he have not stated that there was an oral agreement. You cannot say because you were not born.
Lordship, but in the recommendation letter, yes,
Forget about that. In the recommendation, what he says, I've read,
Yes,
read
clearly
his
stated
document. I've read that document. What does he say? LEC Annexure D, page 26. He says, I would appeal to the appropriate that one post of Sokidar is vacant due to completion of 35 years of service Sokidar. In this connection, I would request the authority to please appoint so and so on the ground that I am the donor of the land. Well, donor would not make any difference out there. Where's the agreement?
but Lordship, way back in the year 1968.
You were not born.
But when the petitioner uncle has donated the land on the best.
But he has to claim, Mr. Counsel. He has to claim. He has not claimed.
Yes, he has not claimed. So
So therefore, he cannot ask that kindly appoint somebody, I have donated the land. There has to be an agreement. It may be that the founder and the chief of Nihoto village, his thing is, why should I'm donating this land, so this is free of cost. Now he thinks you must have gone to him and says that kindly do this and he has issued this. No case.
Lordship, several verification has been carried out as per the direction from the principal, director, and commissioner.
I've seen that.
Lordship.
Kindly see the verification of land ownership which has been given by him.
So until and unless there is an orally agreement, if there was no orally agreement, then those verification was also not required. The government would never direct.
Kindly see page 35. The government, what does it say? In inviting reference to the so-and-so, I have the honor to submit herewith the verification of so-and-so for the post of so-and-so. In this connection, it is stated that the applicant so-and-so is the son of so-and-so, of so-and-so landowner and grandson of so-and-so, the founder of the share and the original donor of so-and-so. Where is the agreement? Then the verification has been sought for on 9th of Iman. Now the verification is being given by the Deputy Secretary. In this regard, land department government policy do not provide employment to landowner in perpetuity and unlimited. I am directed to request you so and so. It noted that a applicant so and so is the son of AR retired and the landowner of GSC Nihoto village.
So there are certain asks to whether Sri Henigi is a landowner of GHS
Then-
Kyoto village or not.
It is not very.
If at all there was no orally agreement, then the respondent authority, the commissioner and the principal director would have never deputed or directed the DC, DO and STO civil to verify.
What is your name?
It's Kekie
H.
Sumi,
Sumi.
Lordship.
And who is Henivi Sema?
He's my father.
Kindly come to page 39. It's also made to learn that though so-and-so is from Nihoto village, he was never appointed as a grade 4 on landowner quota of so-and-so, but his services were utilized at the request of so-and-so for the smooth functioning of the school, since at that time the school was in their formative years and it had no capable hands to do grade 4 assignment. After the retirement, his son's name has been recommended by the unanimous resolution of so-and-so. He cannot request unless that person concerned comes up and says that, look here, I have given this village. There was an oral agreement. Isn't it, Mr. Longkumar? It is kindly see 5/3/2018. In case, and 3, in other cases prior to so and subsequent to setting up of the administrative block headquarters on a freely donated land, where a specific written agreement exists providing for employment to the landowner, the claim of the landowner for employment shall be settled in terms with such agreement. If there is any claim for providing employment as a result of oral agreement, the department shall refer the matter to the Deputy Commissioner of the district, who shall examine such claim carefully, including whether any employment or any other, including so and so. Now, how can you claim? The claim can only be made by that person. He has not said, he says he has not spoken a single word that there was an oral agreement. No.
But Lordship, if at all there was no oral agreement, then as per the office memorandum, the government authorities would never have directed the Deputy Commissioner to verify as to whether any appointment has been granted to the landowner.
So
And they have
if you
clearly-
say the government have taken a precautionary principle and how to find out as to whether there was an oral agreement or not.
They have never stated that in the affidavit as well, and while taking this decision as well.
No, the affidavit categorically says that who are you?
Well,
Which is your locus?
I'm the nephew.
You are not somebody says grandson, somebody says nephew.
No, grandson, it was a clerical error. So I filed my writ petition and I've withdrawn. Because
Who has filed?
I filed. Because in that writ petition, as per the reports, the department, they have mentioned grandson. And the village council, they have also mentioned as grandson and not nephew. So they have rectified, I've enclosed in my next as well. And I've,
So now they say to be the nephew.
yes, Lord.
And what that the doctor says?
Doctors, yes.
What does
Yes,
the
my
doctor say?
father, elder brother.
Hmm? The doctor's letter again.
26, I think.
You have everybody's support. The main support is not
Lordship,
there.
Lordship, can you come to page 47?
Yes, yes,
Annexure
yeah,
B.
yeah, yeah. What does he say?
Page
That
47.
one post of Chokidar. In this connection, I request the authority to please appoint so and so as a clear vacancy on the ground that I am the donor of the land. That he doesn't say a single word.
The last para also in lordship.
My request therefore is to kindly so and so as one of the landlord's recommendation. What is this landlords can recommend? This letter is dangerous for you.
Lordship, can you come to page 47, Annexure V? To the Principal Director by Under Secretary. Verification report of land ownership in respect of GHS New Hotel Village. I am directed to refer to your letter number so and so dated 3/2/25 on the subject cited above and to request the transfer of Sri Angukavi, Lordship, he is respondent number 6, to another school where there is a requirement for an MTS if the services of an MTS is not required at GHS New Hotel. In addition, you are requested to propose the appointment of the candidate recommended by the village council Nihoto against any available vacancy under Dimapur Newland. So the government, they are admitting, Lordship.
Huh?
The government, they are admitting that my uncle has donated land and I should be, as per the oral agreement, I should be.
Where is the oral agreement? Where there is a finding that there was an oral agreement?
But Lordship, the government, they are also not denying that
But
there
where-
wasn't any
but-
oral agreement.
But Mr. Counsel, who is going to tell that there was an oral agreement?
Lordship, my
And why have you appointed the respondent number 6? If these are letters being written by this undersecretary and all.
Your Lordship,
The undersecretary is writing these letters. Why have you appointed the respondent number 6?
Your Lordship, that is.
Well, what do you say
Yes.
about these letters? These are being done on gunpoint.
no.
Then
Without any selection and advertisement,
then-
respondent number 6 was appointed. And they are adamant to
no, you see, kindly come to page 47.
Lordship.
And before that, kindly come page 42. This is being written by the principal director to the commissioner and secretary government of Nagaland.
Yes.
Okay.
Yes, Your Lordship.
Here it says that Anku Gavi, that is respondent MTS, wanted to join, but her joining was not accepted. So she submitted a temporary joining to the district education officer. The government is requested to direct if the directorate of the air should accept the temporary joining and further authenticate the appointment order. Okay.
Yes, sir.
Now against that, the undersecretary writes this letter. Okay.
Yes, Your Lordship.
Now what do you do on this? They say, kindly transfer her to some other place
Yes.
and then consider his case. Isn't it?
Yes.
Now, what is your reply to this?
Your Lordship, but as far as the land ownership
See, land
is
ownership, no
concerned, we
case.
cannot consider because.
No, you have spoiled your case.
Yes, that's true. It's.
What do you say about this? And what happened? This is in 2025.
Yes.
Is the respondent number 6 working? Or there is a stay?
No stay, Your Lordship.
So no stay. Is the respondent number 6 working
As of the date of filing of affidavit, he was still working, but.
in that same place?
Yes, I have not.
So have you transferred her in view of this communication?
No latest instruction, Your Lordship.
Because one of the most pertinent thing is there has to be an agreement.
Yes.
And who can claim the agreement?
The landowner himself.
Landowner.
Yes.
Landowner is not claiming that there is an agreement.
Yes.
Nobody is saying that there is an agreement. Now, can a recommendation of the landowner work?
No, Your Lordship. If we give in to this again, the landowner may come again next time saying he has not
no, as
agreed.
per the OM, landowner ship basis appointment cannot be in perpetuity. So once I have again, I cannot comment.
No, Mr. Counsel, my simple question is very simple. Is, can the landowner make a recommendation that you appoint so and so?
Should be the uncle of the
Because I
petitioner,
donated the land,
being the uncle of the petitioner.
unless there is an oral agreement.
Lordship, there is an oral agreement. That is
Where? Where is the oral agreement?
the records of the government clearly stated, because the principal director as well as the commissioner.
No, show me
have
one,
given
no, Mr. Counsel.
to
show
submit a
me
report,
one
whether
document from your
petitioner husband was, a petitioner father was appointed on land ownership basis. If
No.
at all there was no orally agreement, then such verification was not required.
I'm not on that. Show me one document where it says that there was an agreement. One document. Without the agreement, 3B does not click in.
Lordship, as per us,
3B has to be activated. How do you activate it? Unless there is no oral agreement.
Lordship.
it is in the year 1968, the petitioner.
The petitioner should have mentioned somewhere in the petition that
petitioner-
there wasn't.
No,
Yes,
petitioner
I
should
mentioned.
not do.
Yes.
Petitioner cannot say because he was not born.
Not,
Can you say? No.
yes, Your Lordship.
It has to be the person who had donated the land. He has not said a single word. So without there being a donation, with an oral agreement,
My uncle has stated that there was an agreement.
where? Where? Where is that?
There is no written statement, but however, orally that too.
Where is it? He says that there was an oral agreement to give a land, to give a job.
All
No,
Lordship
just it-
knows very well. Until and unless there was, if at all there was no
Without
orally
that,
agreement.
without that, it cannot happen. This is you see, there are two things. 3A says written agreement and
Yes.
3B says oral agreement. Oral agreement is subject to verification to be conducted. But first, where is the oral agreement? To give job in lieu of land being donated.
If at all there was no oral agreement, then I've stated before, the respondent authority would have never directed the SDO civil, Newland, as well as the DO to verify whether the petitioner father was appointed on land ownership basis or not.
So
So, as per the
they may
report,
verify many things.
they verified and
Neither
stated that
Mr.
the
because
petitioner
you see,
uncle has
no,
donated
Mr.
the
Mr.
land.
Counsel, neither Mr. Longkumar thought that I'm going to put up this question. Isn't it?
Your Lordship.
So these people also may not have thought about it. But there has to be an agreement. Without that agreement, nothing works. Oh, this is. Or next week. Next week or next to next week, not next week.
Lordship,
Next
it
week
will
I
be a
think-
very grave injustice to the
Huh?
petitioners. It will be a grave injustice if my
It's
case.
a grave injustice question because of the fact that you see, this is not a source of recruitment. There's no grave injustice. People normally has to get it as per a selection procedure. Now, if the selection procedure is not being done out there, then why should we? As of now, the instant repetition, you cannot even apply for selection also. You have crossed 35. Now you try for your son. What do you say, Mr. Longkumar?
Yes.
He can't get it.
Not on land ownership basis, Your Lordship.
Land ownership is different, but otherwise also he cannot participate in a selection process also.
Oh, age. Yeah. Age,
It's
yeah.
crossed the 35. So
Lordship.
he can't get it. So the only way out is this. Chalo, we don't dismiss it today. We ask him about the interplay with annexure B and
Lordship, will kindly come to page 31, annexure H. This representation was submitted to the principal director. After appointing the private respondent number 6
Ah,
by the landowner, Dr. P. Nihoto GC, who is the founder and chief of Nihoto village, and by the village council.
So, where is the word mentioned that there was an oral agreement?
As per the office memorandum, it's stated.
I think we need to close it enough. Huh? What do you say, Mr. Longkumar? We finish it off.
Yes, Your Lordship, because even if
This
you
is
go
the-
around,
This is the most
Yes.
important. Everybody has a conception that I donate the land, I can make a recommendation. No, it has to be that the two most important, either there has to be a written agreement
yes,
that land would be given or an oral agreement.
yes,
There's not a single mention by any of these that there was an oral agreement.
yes, Your Lordship.
Mere recommendation would not do. It
Gotcha.
will have far-reaching consequences.
Yes, Your Lordship.
At one point of time, when he gave it out there, he became founder of the village and became very famous. He had taken the fame that in my name I have done, and he have used it also. Kindly see everywhere. His stamp also has.
No.
Dr. So and so, founder, chief, headbeat, so and so, Nihoto village. Kindly see his documented this thing. Where is there his letter? Again?
26,
Huh?
26, page 26.
Yes, here also. Dr. So and so, founder and chief of Nihoto village. He's heading, he has taken this. He became a chief of the village also after donating. How much? 64,000 square feet.
Yes,
Yeah.
62,000 square feet.
Everybody will like this fame. Chalo, we dismiss. Heard Mr. So and so, the learned counsel appearing on behalf of the petitioner. Mr. So and so appears on behalf.
I'm challenging the appointment of respondent number 6 as well.
Huh?
Respondent number 6.
Huh.
I'm challenging his appointment as well.
So why? You don't have locus today. Why should I do it at the instance of you? Are you challenging on the question of it will be a case of a writ of quo warranto? Quo warranto would be a case where a person is being appointed without having qualification. He is not without having a qualification. MTS, no qualification required. And yes, any other person may very well say that I have been deprived from participating in any selection. And respondent number 6 was appointed in the year 2019.
No. 20.
Then why is it mentioned in this letter which you have shown it to me? Kindly see page 31.
26 for 2023. Annexure F, page 28.
23. You filed the requisition in 2025.
Yes.
Before coming to this court, several representation has been submitted before the respondent authority.
You do one thing. I give you one chance. You file an affidavit. Get hold of that person and say that there was an oral agreement from that person.
Not sure.
That is the only way out. Otherwise, you don't have a case. You have not filed a reply.
Reply.
No.
Yeah. Heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner. Mr. So-and-so appears on behalf of the respondent numbers 1 to 5. None appears for the respondent number 6. Those service have been affected. The petitioner hearing claims right to be appointed on the basis of the office memorandum dated 5/3/2018. And therefore, on account of non-consideration of the case of the petitioners for appointment and the respondent number 6 being appointed to the said post, the petitioner had approached this court by filing the writ petition. This court have also taken note of the affidavit in opposition filed by the respondents' authorities, wherein it is the categorical stand that the petitioner have no local standing to file the instant writ petition, inasmuch as merely on recommendations, no appointment can be granted on the basis of the office memorandum notification dated 5/3/2018. The learned counsel appearing on behalf of the petitioner submits that the petitioner would like to file a reply. So taking into account the above, an opportunity is granted to the petitioner to file a reply. This court have also finds it relevant to take note of two communications which have been enclosed to the writ petition. One is the communication issued by the Principal Director to the Commissioner and Secretary to the Government of Nagaland Department of School Education and SCERT, as well as the communication issued by the Undersecretary to the Government of Nagaland School Education Department to the Principal Director School Education, which are annexure S and V to the writ petition. This court would like to be apprised by way of an affidavit to be filed on behalf of the School Education Department of the Government of Nagaland as to what steps have been taken in pursuance to these annexures, being annexures S and annexure V to the writ petition, inasmuch as there is no indication in the affidavit in opposition filed by the respondents in respect to the said respect. List this matter again on, well, June 26.
Much obliged.
Improve your case in that manner.
For admission, item number 4.
Yes. What is this?
Yes, the matter pertains to compensation for the damages caused by petitioner's land. Now, by an order dated 18th of July 2025, this court has passed an order directing the Deputy Commissioner PAG to verify the damages caused to the lands of the petitioner and to submit a report accordingly. In the meantime, at the same time, the DC was asked to assess the damages caused, the amount.
What order has been passed by the DC? What affidavit?
Yes.
has been filed?
Now, yes, Your Lordship.
Affidavit has been filed by the
Yes, an
DC.
affidavit has been filed wherein the report of the DC has been enclosed.
Affidavit filed by
The state.
respondent. Respondent number 7889.
No, respondent 5.
Respondent number 5. Then Yeah, we don't have respondent number 5 then. We are paying for,
Lordship, I'm appearing for respondent 7, 8, and 9, NHIDCO.
who are they?
NHIDCO,
NHIDCL.
Lordship.
Okay. So the money has been already paid.
No, Your Lordship, I'm concerned with the respondent 5's affidavit.
Now, what about this respondent number 7, 8, and 9?
At the moment, I'm not concerned with that because the respondent 5 was directed to verify the damages if
Ah.
and accordingly, the Deputy Commissioner has done that and has filed his report.
So what do you say about respondent 7, 8, and 9's affidavit?
7, 8, and 9, yes, they have stated that the money has been credited to the,
Their money has been
Authorities.
deposited.
Yes. and in the report submitted,
Approved to release the collateral damage compensation amount of 65 and 2 years respectively from the amount which has been recovered from so and so.
yes,
With respect, the Kohima Jesima package has been approved to release collateral damage compensation amount of so and so. So and so, you are in which package?
3, 2 and 3, 2 and 3.
2 and 3, they have already
Yes.
done some
Yes.
amount and
Yes.
deposited in Kala.
Yes.
Then, and how much is your amount?
Now that is in the
These have been
respondent
done in
5's,
2022.
yes. In
Now,
the,
and this amount have been deposited in 2024. Whether you are a part of it or not.
yes, now the respondent 5's affidavit, if Your Lordship can produce.
I don't have it.
Yes, Lordship, we have filed, Lordship.
It is not on record.
I mean, they
It has been submitted at the bar that the respondent number 5 has filed an affidavit. It is also, this court also takes note of the order passed by this court. This court also takes note of the order dated 18/7/2025, whereby there was a direction upon the respondent number 5 to submit a report. Considering the above, as the report affidavit of the respondent number 5 is important for an adjudication of the instant proceedings, the registry shall bring on record the said affidavit so filed on. When did you receive a copy?
I received on
Anybody?
22nd of May.
You don't know.
No, Lordship, I have served the copy, Lordship.
No, you are respondent number 5.
Yes,
Yes.
When did you file?
on 30th, Lordship. 30th of this month.
30th of
Apology, Lordship. 30th of May.
May. Has it come?
Sorry.
30th of May.
27th.
I,
It was
I
filed on 27th.
received on 22nd May.
Huh?
I received on 22nd May.
You filed it on 27th.
Lord,
Possibly.
this, since this is not my matter, Lordship, not much aware of the date.
You are not filed.
We have filed, Lordship.
When?
I'm sorry, Lordship, but I forgot the date, Lordship.
Which have been filed. Whose list accordingly after 2 weeks.
For admission, item number 5.
By please, Lordship.
Hmm.
Lordship, I'm appearing on behalf of Zakatuchi, Counsel for Petitioner. He has some family problems, so I have instruction to list the matter on Tuesday.
At the request of the counsel for the petitioner, matter stands adjourned to be listed on
Tuesday, 2nd May.
22nd May. 22nd May?
Yes.
It's over?
June.
22nd of June.
Yes, Lordship.
And to be listed after 3 weeks. There's no interim order.
For admission, item number 6.
May I please, your Lordship? Lordship, here I'm for a state respondent, Lordship. Lordship, I'm here to file my affidavit, Lordship. If Lordship may please release the matter next week. In the meantime, I'll
Mr.
file
V.
my affidavit.
Jimomi, the learned counsel appearing on behalf of the state, have sought for time for filing of the affidavit.
My lord, I'm appearing for the petitioner, lordship.
Yes, what do you have to say?
My lord, on the last occasion, they were given last opportunity to file the affidavit, lordship, on 20th/3/2026, 20th March,
Do one thing, we impose a cost of 10,000 upon them.
Lordship,
lordship.
Lordship, I have sent it for vetting, Lordship, and I'm waiting for. In
My
fact, there was a.
goodness, I gave it 2 months to file.
Yes, lordship, that is exactly, lordship.
Lordship, in fact, I have, filed, but due to some errors in the while filing, Lordship, I have to revert it
It
back.
cost 10,000.
Lordship, Lordship,
Mr. V. Jimomi, appearing on behalf of the respondents, seeks for another opportunity to file the affidavit in opposition. It is seen that by an order dated 23/2026, this court granted a final opportunity to the Chumikidemab Municipal Council to file the affidavit on or before 25/5/2026. Then also, no affidavit has been filed. Considering that a further request is being made, this court grants another opportunity subject to payment of cost.
Lordship,
Accordingly, list this matter again on 25th of June 2026. Another opportunity is granted in the interest of justice, subject to deposit of a cost of rupees 10,000, which shall be a condition precedent for acceptance of the affidavit to be filed by the Chumikidemab Municipal Council. Full stop. The said amount of cost so deposited shall thereupon be transferred to the the District
Lordship, in
Legal
fact,
Service Authority, Kohima.
apology, my lord. Lordship, in fact, I have already filed, but however, due to some errors in the.
I can't help it. It has not come after 2
Since-
months. If you cannot,
And Lordship, I have sent it for vetting, Lordship. Actually, it was.
you
supposed
say
to
that you have
be-
filed. You say that you have sent it for vetting.
In fact, initially I filed, but it was rejected, and again I have to send it back
For vetting.
for signature, Lordship.
For vetting.
Lordship, for signature, Lordship.
I can't get you. I can't allow you.
Lordship,
Because
from the
final
registry, it was
opportunity-
already been rejected, Lordship. And then I was not aware of that, Lordship.
Okay, make it 15,000 cost.
Obliged, lordship.
10,000 cost to be paid to the dealer. You file an appeal against it. One has to be serious. I gave it 2 months, not
Lord-
1 month, 2 months.
Lordship, I have already filed.
23/2026.
Yes, lordship.
Fixed it on 25/5/2026. After 2 months, if you don't file it, I think why should I give you an opportunity? Or you say that, okay, I'm going to argue without my pleadings. Very well. We strike out your defense and then proceed.
Lordship, then I will argue the matter, Lordship.
Without that.
Lordship, without a affidavit.
You want to do the matter now?
Lordship.
Yes, Mr. Counsel, argue.
Yes, my lord, I'm imputing the termination order of the petitioner, lordship. It's at Annexure D, lordship, the approval, and Annexure E, lordship. Now, as per the appointment, lordship, a prior 1 month
Where is
notice has
Annexure
to be
D?
given, lordship.
Annexure D.
Annexure D, yes, and D and E, lordship.
Yes.
So,
Matter
lordship,
regarding the appointment under Sumigiri, in inviting reference understanding directed to convey that the administrative approval so and so for appointment to various posts and as that is hereby cancelled. Okay.
yes, lordship, and Annexure E is the cancellation order, lordship.
Yes. Then
Now, if I may take my lord to the appointment first appointment order. 15, page number 15, lordship, Annexure A.
yes.
3 persons were appointed, lordship.
Then
This is the approval, page number 15, and appointment order is at page number 16, Lordship.
Okay. Then page number 16 is the order.
Yes, Lordship, appointment order, Lordship. It's the,
Okay, then. So
now,
you,
Lordship,
why are you, means the appointments are temporary and
Yes,
liable
Lordship.
to termination.
liable to be terminated, yes.
And
absolutely,
giving
Lordship.
1 month's notice.
Yes.
You may at best be entitled to 1 month's salary, more than that. That's it.
Lordship has rightly pointed out, Lordship. Lordship, if we go by the, from the face of the report, Lordship, page 16, Lordship, it's clearly stated that from the appointment order, it's clearly
It's
stated.
temporary and liable for termination.
Lordship,
Now,
Lordship.
second, if you see the appointment of so-and-so is purely on temporary and which can be terminated within 1
With
month.
1 month notice, Lordship.
Be
That
entitled
was
to
not done,
1 month's salary, that's all,
Lordship,
which you pay, matter over.
Lordship.
My lord, just
Instead of
one,
paying 10,000, he wants to go for that.
Lordship, just,
Like I have already filed, but it was rejected and I have to send it.
Okay, we dictate.
Lordship, just one more submission. If in the alternative, Lordship, allow me to just make one submission. Lordship, now the cancellation order and the termination order is simply, it simply says that it stands cancelled. Now, after I submitted my representation for consideration of my reinstatement, now they have given a reply on page 21 that on account of limited resources, they are unable to reinstate my service. That was the reply, Lordship. But that was made only on 28 June 2023, Lordship. So it is just my simple submission, humble submission, that this, first, the cancellation order is not a reason order. Second, this reply to it is an afterthought of financial crunch, a plea of financial crunch, Lordship. Now,
Yes, tell me.
now, my lord, they have not placed any affidavit to support this reply, Lordship. Opportunities were given for them to at least supplement how the financial crunch, the reason given here, how the financial crunch was occasioned and what is the status.
But Mr. Counsel, why have you approved after 2 years? 3 years?
Lordship.
Lord, I have been submitting an
No.
representation after representation, and they have always already.
That's out there which says that mere submission, not due. If you were terminated in 2022 in the month of August, what?
Yes, Lordship.
Why have you approached this court in the year 2025?
Yes, my lord, I have.
We do one thing, we say that, okay, that you will be entitled to 1 month's notice, you were entitled to, however, in respect to that, you will be given 1 month's salary.
Lordship.
Yes, my lord, just in the alternative, if a direction may be given to the state respondents to consider my case, if I'm
No, my lord.
stating the reasons why she cannot continue, and if at least give me a chance to check the bona fides of that reply, Lordship.
Thing is like
That
this.
order.
In last 4.5 years, I've been
Yes,
at,
Lordship.
I have passed only in one or judgment
Yes, Lordship.
directing for consideration.
Yes,
One
Lordship.
that- And that is a reported judgment.
Yes,
And
Lordship.
that too, after writing 40 paragraphs, I directed them kindly consider. And consideration, if I give, I also gave within what parameters you are to consider. Very specific. That was a case I still remember. These NHM people, they engage nurses. These nurses, they wanted to become in the services of the state to be regularized. I can't pass a direction for regularization this is under a particular scheme. So I said that no, nothing doing. I'm not going to do anything to that effect. I can't pass that order. However, I said that they have these legitimate expectation. These are the things, how many years they have put in service. If they don't get all these things, then what will happen? Then I said, within these parameters which I have indicated, kindly consider. Only one judgment. So therefore, when I don't pass these type of orders, it's not possible. So the only way out is you are entitled to 1 month's salary, which Mr. B. Jimomi will pay. Should I say that? No, not you. Chumikidima Council will do it. Would I put it as a consent order or not? 1 month salary to that was the term of his appointment. How many persons are here?
Three.
Huh?
Uh,
How many
uh,
petitioners?
only the
One lordship.
Only
So,
the So you have to pay 1 month. Anyways, heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner. Mr. V. Jimomi appears on behalf of the respondent numbers.
all the respondent.
Shumikirima Town Council is under the government.
Lordship.
Huh?
Lordship.
As on behalf of all the respondents.
All-
You will be in trouble.
Lordship.
You
No, as
go and
for
Madam, you appear for 1, 2, and 3. And let him appear for 4. Better off.
yes, lordship.
Because otherwise there will be again a
The
conflict.
administrator and executive officer, then it comes, it is a government, this is a government.
Yes. Yes, lordship.
Administrator and executive officer. Otherwise, the Chumukedima Town Council, they will have a chairman, chairperson, yes.
Yes.
But this is a government lordship.
Okay.
ATC holds the administrator and executive officer.
In fact, he should have made the town council as a party.
Lordship.
At that point of time, lordship, the new municipal act was not enforced, lordship.
So and so appears on behalf of respondent numbers 1 to 4. The petitioner herein is aggrieved by her termination by the order dated what is the date of the order? 18/10/2022.
26th August, lordship, 2022.
As well as the subsequent order dated 19/10/2022, both issued by the order dated is agreed by the communication dated 18/10/2022 issued by the Joint Secretary to the Government of Nagaland to the respondent number 4 and the consequent order dated 19/10/2022 issued to the petitioner. The petitioner had also submitted a representation. However, the said representation was not considered. And it is under such circumstances the present petition has been filed. The materials on record show that on 25th of August 2022, the Principal Secretary to the Government of Nagaland, Municipal Affairs Department, have written a communication to the administrator, to the respondent number 4, thereby granting the administrative approval for appointment of the various candidates, including that of the petitioner as the assistant inspector. In the said administrative approval so provided by the communication dated 25/8/2022, it was categorically mentioned that the appointment was temporary and liable for termination. Subsequent to the administrative approval so granted, the respondent number 4 issued an appointment letter to the petitioner, issued an order, thereby granting appointment, thereby appointing the petitioner to the post of assistant inspector in the establishment of Chumukidema Town Council on a scale of pay, on scale basis. In this order dated 26/8/2022, it was mentioned that the appointment of the petitioner was purely on temporary basis, which can be terminated with 1 month's notice. For the purpose of the present dispute, this court finds that the contents of the order dated 26/8/2022 to be of relevance, and as such, the said contents are reproduced hereunder. The petitioner thereupon joined on 2/9/2022 subsequent thereto, on 18th of October 2022, the Joint Secretary to the Government of Nagaland issued a communication to the respondent number 4. This communication was in reference to the administrative approval which was granted on 25/8/2022. Thereby informing that the administrative approval stood cancelled. The consequential, in consequence to the said communication dated 18/10/2022, the respondent number 4 issued a communication to the petitioner on 19/10/2022, intimating the petitioner that on account of the administrative approval having been cancelled, the appointment of the petitioner was also cancelled. The contents of the communication dated 19/10/2022 being relevant is reproduced hereunder. The petitioner thereupon submitted an application for retention before the advisor, Urban Development and Municipal Affairs, Nagaland. In reply to the said communication, this is dated what?
10/12.
12 is nothing. No. So this communication thereupon was forwarded. I think so, no? It must have been forwarded.
Yes, Lordship.
Forwarded. Full stop. To the respondent number 4. The respondent number 4, by the communication dated 28/6/2023, informed the additional director and HOD, Directorate of Municipal Affairs, that there are already 2 sanitation inspectors and MRC inspector, as well as 2 assistant sanitation inspector and assistant MRC inspector appointed under the Chumukidema Town Council. It was also mentioned that there was limited resources, and as such, the office was not in a position even to manage the basic minimum salary of the existing staff. It was also mentioned that in the Chumukidema Town Council, there was overemployment. This aspect was duly informed by the additional director and HOD, Directorate of Municipal Affairs, to the Commissioner and Secretary, Urban Development and Municipal Affairs. The petitioner thereupon again after 1 year, sometime in the year, again submitted two representations. The petitioner thereupon submitted again representation on 29/10/2024 to the Director, Department of Municipal Affairs, as well as the Commissioner and Secretary, Department of Municipal Affairs, Kohima, for reinstatement for her reinstatement as Assistant Inspector in the establishment of Chumikidema Town Council. However, those having not been taken into consideration, the petitioner has approached this court by filing the present petition. The records further reveal that this court had issued notice. The records had filed the writ petition on 24/7/2025. The records further reveal that this court had issued notice. No notice. No notice. No notice. No notice. The records reveal that since 28/7/2025, the writ petition has been listed on various occasions, but no notice till date have been issued. The respondents also have taken various opportunities to file their affidavits, but no affidavit has been filed. This court have heard the learned counsels appearing on behalf of the parties. And the question arises, upon hearing the learned counsels appearing on behalf of the parties, the question arises as to whether this court should interfere with the cancellation of the appointment order of the petitioner, which have been quoted herein above. The materials on record clearly show that the petitioner initially was appointed as an assistant inspector pursuant to an administrative approval. Both in the administrative approval dated 25/8/2022 as well as the appointment order of the petitioner dated 26/8/2022, it is categorically mentioned that the petitioner's appointment was temporary. Further to that, it was also mentioned in the order dated 26/8/2022 that a petitioner appointment can be cancelled by giving 1 month's notice. Pursuant to the appointment order dated 26/8/2022, the petitioner joined on 2/9/2022. The records further reveal that on 18/10/2022, the administrative approval on the basis of which the petitioner was appointed was cancelled. And the resultant effect was on 19/10/2022, the petitioner's appointment was cancelled. The appointment was terminated. This court have also taken note of the reasons assigned as to why the appointment was cancelled. Inasmuch as it is the send of the respondent number 4 in the communication which have been enclosed by the petitioner, communication dated 28/6/2023, that the Chumikidema Town Council did not have the resources to keep the petitioner under employment. Under such circumstances, this court had given an anxious consideration to the appointment order of the petitioner as well as the termination order. The appointment order made it apparently clear that the termination was permissible subject to 1 month's notice. It is therefore the opinion of this court that while terminating the petitioner, either the 1 month's notice ought to have been granted to the petitioner, or salary for 1 month ought to have been granted. First, taking into account that the Chumikidama Town Council does not have the resources, as have been stated in the communication dated 28/6/2023, and their administrative approval have been cancelled, and there is no stigma attached to the termination order, it is the opinion of this court that the question of granting and interfering with the order on the ground of non-issuance of a notice would not be in the interest of justice. Accordingly, the writ petition stands disposed of with the following observations and directions. This court is not inclined to interfere with the communication dated 18/10/2022 issued by the Joint Secretary to the Government of Nagaland to the Administrator Chumikidama Town Council, Annexure D to the writ petition. Number 3. This court is not inclined to interfere with the appointment cancellation order dated 19/10/2022 issued by the respondent number 4 to the petitioner, insofar as cancellation of the termination of the appointment is concerned. However, this court observes and directs that the petitioner herein would be entitled to 1 month's salary, which was the requirement as per the appointment order dated 26/8/2022. Number 3. This court directs the respondents herein jointly and severely, and more particularly the Chumikidama Town Council, as well as the respondent number 4, to make payment to disburse the amount 1 month's salary to the petitioner as it stood at the time of her appointment within a period of 45 days from the date a certified copy of this order is served upon the respondent number 4. With the above, the petition stands disposed.
Right, Lordship.
For admission, item number 7.
Yeah, please, Lordship. Lordship, I have received the latest instructions, Lordship. When the case of the petitioner is under process and he stands in serial number 1, Lordship. So if, may I please?
So we dispose it of in terms with this
Lordship.
and
Yes,
giving him the benefit of the year from the date on which the petitioner is entitled to 1/8/2024. Heard Ms. So-and-so, the learned counsel appearing on behalf of the petitioner. Ms. S. Young appears on behalf of the respondents. The petitioner herein is aggrieved by the non-consideration of his case for regularization in terms with the office memorandum dated 17/3/2025. And it is under such circumstances the writ petition has been filed. It is the case of the petitioner that the petitioner was appointed on 28/7/1994 as a work charge employee, work charge fitter helper under the office of the Executive Engineer PhD, Twensang Division, Twensang, Nagaland, in the scale of pay with effect from 1/8/1994. In the month of August 2024, the petitioner was eligible for regularization in terms with the office memorandum dated 17/3/2015 and therefore submitted a representation on 11/8/2025 to the Chief Engineer PhD, Nagaland, Kohima for regularization of his service. However, there was no response to the representation, and it is under such circumstances the petitioner approached this court by filing the present writ petition on 15/9/2025. The records reveal that this had an order dated 16/9/2025 issued notice. In pursuance to that, though no affidavit has been filed by the respondents, but today, Ms. S. Young, appearing on behalf of the respondents, have placed before this court an instruction dated 26/5/2026. The instructions so placed are collectively kept on record and marked with the letter X. This court finds it relevant to take note of the comments and status of the petitioner as have been mentioned in the said instruction, which is kept on record and marked with the letter X. The comments and status qua the petitioner being relevant is reproduced hereunder to page 2. From the above, it is seen that the petitioner's case is under active consideration, but on account of there being certain stages, certain approvals required from various departments of the government of Nagaland, the petitioner's regularization have not yet been given effect to. This court have taken the first. It is the opinion of this court that the petitioner is entitled to regularization in terms with the office memorandum dated 17/3/2015, in terms with clause 1 Roman 2 on 1/8/2024. This court understands that there would be certain delay on account of the procedural, on account of approvals being required from the various departments. Because under such circumstances, this court disposes of the instant writ petition with the following observations and directions. Number one, the petitioner is entitled for regularization in terms with clause 1 Roman 2 of the office memorandum dated 17/3/2015 with effect from 1/8/2024. Number 2, the respondent authorities are directed to take active steps for regularization of the petitioner in terms with the office memorandum dated 17/3/2015. Number 3, the petitioner be granted the regularization with the date from the date that the regularization of the petitioner shall be with effect from the date the petitioner he was entitled for regularization, that is on 1/8/2024. With the above, a copy of the present order be furnished to the Chief Engineer and HOD PhD Nagaland for due compliance.
Your lordship, specific time period may be granted.
I've given that you will be given with effect from 1/8/2024.
Yes, your lordship.
So whatever may be, they will be doing it. And for due compliance, number 2. Is entitled to regularization or yeah. So and there will be the under such circumstances, this court further observes that the said steps be taken as expeditiously as possible and preferably within 6 months.
Much obliged, much obliged.
You have retired?
Not retired yet. I will be retiring in 2029.
It's
Obliged.
taken within a period of 6 months.
Obliged, lordship.
For admission, item number 9.
So this is a copy of the order be given for the purpose of here.
May I please, your lordship? Lordship, I have just received the affidavit filed by the state. So if I may be granted 2 weeks' time to file my reply. I just received it 3 days back, my lord.
Ms. So-and-so appearing on behalf of the petitioner submits the affidavit in opposition on behalf of the respondent number 5.
Lordship, respondent number 1, 2, and 8, my lord. 1, 2, and 8.
Respondent number 1, 2, and 8 have been received by her only 2 days back, and therefore the petitioner would like to file a reply. How much time?
2 weeks, my lord.
Okay, list this matter again on 19th of June. In the meantime, the affidavit in reply be filed on behalf of the petitioner.
May I please, Lordship? There is urgency if it can be done in a short period because
Lordship, this is the first time I am praying for time since I have just received it, my lord.
What is the order case? What is the case about?
My lord, this is here the petitioners are the Lotha Baptist Church Association. My lord, so I'm aggrieved by the order passed by the DC handing over the properties of the church to the private respondents.
otherwise they are only
They filed the affidavit on or before 17th of June 2026. List the matter on 19th.
Lordship, this is the status quo order, if that can be.
Status quo order passed earlier shall continue. The interim order passed earlier shall continue till the next date.
Maybe obliged.
For admission, item number 10.
Please, Lordship. Lordship, I have instruction that we'll be withdrawing the termination notice.
You produce that order
Uh,
next week.
Yes, yes. But Lordship, I pray that there should not be a bar for us to take any step as per the law.
It's a
if
different thing.
necessary.
You always have, but on the basis you
Lordship.
should also have something.
Exactly, Lordship.
You can't have the basis for
Lordship.
termination. Termination is, you don't do it in this manner. Anyways. Because of filing a case, it doesn't, so it's, Ms. B. Supurohit, the learned additional advocate general, submits that she has been instructed to inform this court that the concerned respondents would be withdrawing the notice of termination dated 31/3/2026. It is the opinion of this court that the said aspect be brought on record by, it is the opinion of this court that such withdrawal of the termination, notice of termination dated 31/3/2026 be placed before this court in black and white. Considering the above, list this matter next week
Lordship.
on, when do you can vote? On vote for production of the said document.
Lordship.
For orders, item number 11.
Maybe extend it.
Interim order passed earlier shall continue till the next date. Yes, madam.
Lordship, on 16/3/2026, direction was given to the petitioner to file additional affidavit, which we have complied with, Lordship. Also, Lordship, regarding the notice to respondent number 3 and 4, we have taken steps to through Dusty initially, Lordship, on 24/2026, Lordship. They refused to accept notice. And again, we have taken steps for sending notice through Sweet Pulse, Lordship, as directed.
Now, have you filed the affidavit, madam, of service by way of the state?
Lordship, yes,
Where-
we have filed. Filed, Lordship. In fact,
When did you file it? Affidavit is not here now, madam. There was a direction on 14/5/2026, wherein it is said that the petitioner shall file an affidavit envisaging service of notice upon the respondent number 3 and 4 by way of the state. Have you filed that?
Lordship, yes, we have filed, Lordship.
When?
Lordship, I'm a little lost with the date, but Lordship, it was, affidavit was filed last week, Lordship. Then there were some defects. We cured the defects again.
Okay. It has been submitted by Ms. N. Khoza, the learned counsel, appearing on behalf of the petitioner, that in pursuance to the order dated 14/5/2026, the petitioner have already filed the affidavit. However,
Lordship,
the
yes.
same is not on record. The registry is directed to bring on record the said affidavit of service so filed by the petitioner. This is the matter again on 4th of June 2026.
Right, Lordship.
Much
For-
better.
Is there
For-
interim order, madam? No interim order.
Interim order, Lordship.
The interim order passed earlier shall continue till the next date.
Obliged, Lordship.
Much better.
For orders, item numbers 12 and 13.
Yes, what is this?
May I please, your lordship? Lordship, we have filed an application for substitution of the petitioner, Your Honor, on account of the petitioner's death.
Huh?
The first petitioner, he died, Your Honor, on the 12th of January 2026. And so we have filed this application for substitution of the legal heir.
What is the case about?
Your Honor, your lordship, I'm not the main counsel in this petition, your lordship. So your lordship may kindly allow.
Well, what are you asking for?
We are asking that the petitioner be substituted with the wife, your Honor. That is the legal here.
So you want some prize money?
Yes, your Honor. That is the.
Yes, my lord.
You want some prize money?
Yes, he wants some prize money,
Ah.
but he has purchased that prize money, the lottery ticket, from a broker. And there is a provision, clear provisions laid down by the central.
That's a different thing.
Yes.
But there is a prize money.
Yes, prize money holder.
So,
Yes,
he had the person Joydeep Dutta
yes,
who died. He had the lottery ticket.
yes,
He purchased it through a broker, so you say that he's not entitled to.
yes, my lord.
So therefore he filed a writ petition.
Yes, my lord.
Now, the claim on respect to the prize money amount obviously goes to the legal representative.
Yes,
Yes, my lord.
So then why are you objecting?
My lord, now against the winning of the lottery ticket by the petitioner, we have already lodged a complaint before the North Police Station, Dimapur, Kohima. So that complaint is still under investigation. And my lord, while the case, this writ petition was pending, the petition expired on 12/1/2026, and they have filed a substitution after a lapse of 90 days. So which we have filed an objection also, saying that since the substitution has to be filed within a period of 90 days as mandated under Order 22, Rule 3 of the CPC.
You have
And-
the CPC?
Yes,
You
my
have the CPC with
Yes,
you?
my lord.
Take it out. Read 141.
Yes, 141 is there. But along with that, he has not filed any condemnation application
Not
also.
necessary. The condonation does not arise in 226.
But Puran Singh case is
How
also
do you
covered.
file a condonation? Tell me. In 226, how do you
Yes.
file a condonation?
My lord,
Tell
in
me,
support of my...
read appeal.
Yes,
The condonation is under what provision?
Section 5 of the limitation.
No.
Yes.
It is because of the rules. In terms of the rules, you have to file within 30 days. The spirit of the Limitation Act will apply. In a 226, is 226 a court?
Yes.
No, it is not a civil court.
My lord, in Puran Singh
Limitation
case...
Act, Mr. Counsel, Limitation Act only applies to civil courts,
Yes, my lord.
not this court.
My lord, there is a judgment passed in the Puran Singh case
Where?
in the writ petition also, the Limitation Act will apply.
Where?
It's reported in 1996 2 ECC 205.
What does
in
it
Puran
say?
Singh case,
Show me.
please.
How does the Limitation Act apply in 226? Let us also be alert.
Relevant para is para 8, 10 and 12. Yeah, please. Para 8.
Yes.
But then can it be said that as the provisions of Order 22 of the Code are not applicable to the writ petition, the party who has invoked the jurisdiction of the High Court by filing such writ petition under 226 and 227 of the Constitution is at liberty to proceed with such writ petition against a dead respondent? Can the High Court pass an order without hearing the legal representative of such deceased respondent, even in case where right to sue survives against the legal representative of such deceased respondent? If such representative is not brought on the record, any order passed against the original respondent after his death shall not be binding on them because they have not been heard. The order of the High Court shall be deemed to have been passed against a dead person. If the right of the petitioner to pursue the remedy survive even after the death of the original respondent to the writ petition, then on the same principle, even the right to contest that claim survives on the part of the legal representative of the deceased respondent. In such a situation, after the death of the respondent, if the right to sue survives against the legal representative of such respondent, then the petitioner has to substitute the legal representative of such respondent before the writ petition can proceed and can be heard and disposed of. The petitioner has to take steps for substitution of legal representatives within a reasonable time. it need not be impressed that it will not be
Not
unreasonable.
satisfied. Okay, we allow his application. But why are you filing one application for both?
Your Lordship, we have filed this IA application, and it was listed on the 14th of May of this month, Your Lordship. And we have also already given that we will be submitting our condonation of delay.
No,
Yes.
condonation not necessary. I'm not on that. Why have you filed one application for both writ petitions?
Because they are connected, they are the same connected
Mr.
matters.
Counsel, there has to be two applications.
Yes, sir.
Anyway, you filed the other application. Here I'm substituting it. But this is defective in that regard, Mr. Counsel. You cannot file
Yes,
one
Your Lordship,
application.
there are principles laid down by the. I do not have the judgment with me, but there's this principle that length of the delay is immaterial.
Not necessary, Mr.
Yes,
Counsel. Don't worry.
Yes, Your
I'm willing to allow it. But the fact is, why have you filed one application?
Your Lordship, they are so
Maybe,
close
but you have to file
connected.
two applications.
Yes,
You filed
yes,
the other application.
yes, Your Lordship.
Anyways, this application will construe where?
Uh,
In which case do you want this?
It will be for 135 of WPC 135.
135.
Yes, Your Lordship.
And for 135, 36, you'll file another one.
Yes, Your Lordship.
Shall- Heard Mr. So-and-so, the learned counsel appearing on behalf of the applicant, and Mr. So-and-so who appears on behalf of the respondent numbers
3 and 4.
3 and 4. Mr. Angami appears on behalf of the respondent number 1, 2,
5 and 6.
5, and 6. This is an application. The present application has been filed seeking substitution of the legal heir of legal representatives of the petitioner who expired on 12/1/2026. First, this court duly takes note of the cause of action for which the writ petition, being WPC number 135/2025, have been filed. And in the opinion of this court, the legal representative, the right to sue survives upon the legal representatives of the deceased petitioner. Accordingly, it is therefore, this court therefore substitutes the
Wife, Your Lordship.
the legal representatives of the deceased petitioners whose names have been mentioned in paragraph number 4 as petitioner number 1.1 and 1.2 to the accompanying writ petition. This court also takes note of that the instant application has been filed in two application has been filed for two writ petitions which have been tagged together. It is the opinion of this court that the petitioner would be, the applicants would be required to file separate application. Be that as it may, as the learned counsel appearing on behalf of the petitioner have elected that the instant application shall be qua the writ petition being WPC number 135/2025, the instant order shall be only applicable in respect to WPC number 135/2025. The counsel appearing on behalf of the petitioner is directed to file a fresh memo of parties before the registry of this court, and the registry shall, on the basis of the present order as well as the memo of parties to be filed, which is memo of parties so filed, shall make necessary changes in the cause title as well as update the same in the CIS. Next, I stands disposed. Before parting with the record, this court observes that in addition, that as there was a mistake on the part of the counsel in filing one application in against two writ petition, liberty granted to the applicant petitioners to file a separate application in respect to WPC number 136/2025. The Land Council submits that within 7 days, the said application within 7 days
Yes, Your Lord.
would be filed. So considering the above, the leave so granted. I dispose this. And so upon correction, you file it within 7 days.
Yes, Your Lord.
Not only here, there. Memo parties within 7 days, huh?
Much obliged, Your Lord.
For hearing, item number 14.
Yes, what is this?
Your Lordship, I'm applying for death, gratuity, and leave engagement. The petitioner is the foster mother of the disease. And the disease has been working as an employee of KVK Krishi Vigyan Kendra under the Department of Agriculture, Nagaland. So after his disease, we applied for leave engagement and that gratuity. But till today, it was not released. So the petitioner was constrained to file this petition before this honorable court. There was an MOU executed between the Krishi Vigyan Kendra and the Department of Agriculture on 8 December 2005.
You are a foster mother?
Yes. Your Lordship.
What is this foster mother business?
No,
Are you the legal guardian?
yes.
Are you the legal guardian of the child?
Yes, Your Lordship. The legal guardian and the she is the holder of the succession certificate and the guardianship certificate.
You have taken the guardianship certificate. Where is that?
Yes, it's in process annexure D. D and D1 page. Page. Yes, annexure A, page 39. Got page 41. That is the certificate. Page 41. This is the guardians.
Now why they are saying you are not going to get it? Yes, madam, why you are not giving?
Your Lordship, here the petitioner is not a government servant, Your Lordship. He was appointed under a scheme, Your Lordship.
Scheme?
So yes, Your Lordship. Your Lordship, if you may go through my affidavit, Your Lordship, Your Lordship, in the writ petition, Your Lordship, the appointment order is very clear, Your Lordship.
Where?
Page 32 of the writ petition, Your Lordship.
Is hereby appointed to the post of training under the establishment of ARKVK under district in the scale of pay sanctioned by ICR. The post and will be terminated and when stops funding. There is no provident fund pension. Okay. What is this career advancement scheme? Next. This is a central government scheme.
Yes, Your Lordship.
You are central government.
Sorry, Your Lordship. No, 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 I'm for the state, Your Lordship.
Is the central government
Yes.
a party?
No, Your Lordship. Even Your Lordship, in my petition, I've stated they have not implemented the necessary party, Your Lordship.
Mr. Counsel, you have to make the central government a party.
Your Lordship, the MOU is very clear. The MOU is very clear that it's very clear from the MOU. It's annexed in page, the Thai copy is at page 63. The state government, the responsibility have been divided between the KVKs and the state government. And likewise, the state government has been acting upon this agreement. They have been exercising the power of administrative control. All the appointment, promotion are being done by the state government. And the salary was paid by the ICAR. It's very clear from the MOU. And my claim for this debt gratuity arises out of this MOU.
No, Mr. Counsel, you have to make it. You see, kindly come to page 65. As per the memorandum, the council, that is the first party, shall provide grant for the project of Krishan Vigan Kedra according to the pattern of assistance approved under scheme subject to the personal and budgetary limitation imposed by the Government of India from time to time. The items of assistance may entirely include salary assistance in respect of component scientists and technical staff in different lane, assistance of salary in respect to modest office staff necessary here, the costs of approved so and so. So therefore, ICAR has to be made a party.
Yes, Your Lordship.
Treat KVK staff at par for the purpose of privileges, amenities, and facilities permissible to other staff of the grantee.
Yes.
So therefore, you have to make them, because you see, they don't pay from there, they get the money. Your salary also, they got the money from ICAR.
Yes, Your Lordship.
So it is still a centrally sponsored scheme.
Yes, Your Lordship.
If it is a centrally sponsored scheme or a central sector scheme, I don't know much on that. That has to be looked into. But at the end of the day, the union has to defray the cost. So you make him a party.
Okay, Your Lordship.
Okay.
Okay, Your Lordship.
The learning counsel appearing on behalf of the petitioner submits that taking into account the objection taken in the petition, in the affidavit in opposition that necessary parties have not been implemented. The petitioner would like to file appropriate application seeking the implement of the Union of India as Ministry of Agriculture as well as the ICAR. So taking into account the above, this court directs the instant writ petition to be listed upon such application is filed. Yeah. 1 o'clock finished.